thank you also for helping homeowners on a daily basis. We know that you all do the heavy lifting out there, and we appreciate that. Now I want to launch right into the rules, because it's our hope that these will help you on a daily basis as well in representing your clients. With respect to the rules, just some housekeeping. On my part, standard disclaimer, essentially at the end of the day, you should go to the rules if you have any questions. There is a link at the end of this PowerPoint on the last page to a lot of great information, including the regulatory text and preamble. So again, I would encourage you all to go straight there. But this presentation, in sum, is meant to help you issue spot and have a general understanding of the rules. So let's start at the very beginning. Early delinquency protections. Let's say you have clients, Mary and Bob, and if you're lucky, they haven't defaulted yet. I know, highly unusual probably for a lot of you, but let's say they walk in your office and they're about to default. Well, there are some protections that they have regardless of whether they do anything or not. And the protections that they have are as follows in the early delinquency phase. At 36 days, the servicer is supposed to reach out and engage in live contact. At 45 days, the servicer is supposed to provide written notice to them, as well as assign continuity of contact, i.e. single point of contact, which I'm sure you all are familiar with. And one of the biggest protections is that until 120 days, a servicer, with 2 exceptions, is not supposed to commence a foreclosure filing, irrespective of anything that Mary does. So let's talk about these a little more in depth. So early intervention and continuity of contact. So here what we have is by the 36th day, the servicer is supposed to make a good faith effort to engage in live contact with the borrowers. With respect to continuity of contact, and let me just back up, at the 45th day, the servicer is supposed to provide written information to borrowers, telling the borrowers how they can begin to apply for a loan modification application, if not the requirements of what that loan modification or loss mitigation application should contain. At the 45th day, like I said earlier, the continuity of contact also kicks in. So servicers are supposed to have policies and procedures to assign support personnel. Now, they don't necessarily need to assign just one person, but in sum, this person or set of people is supposed to be able to assist the borrower by phone with loss mitigation options, including advising the borrower on the status of any loss mitigation application or applicable timelines. They should be able to access all information provided by the borrower and provide that information where appropriate to those who are evaluating the borrower for loss mitigation options, so those within the servicer's organization, underwriters, etc. I want to emphasize that this is a very important person for the reasons that you all know. They at least should be an important person in terms of trying to provide accurate information about loss mitigation options. But also there's a lot of deadlines that you're going to see that I'm going to talk about throughout the rules. They should also be able to talk about those deadlines, including where the homeowner is there a notice of sale scheduled, things like that. They should also be able to tell borrowers really critical information, including how to appeal and what's the status of their loss mitigation application. Is it complete? They should also be able to provide the borrower with information about how to obtain a complete record of their payment history, as well as provide the borrower with information about how they can request error corrections or information from the servicer. So this really is a person that is supposed to provide the borrower with a lot of information that will help you help represent your clients at the end of the day. And for those of you who have been in this world, I'm sure you're familiar with single point of contact. But now this is a federal requirement that servicers have to have policies and procedures to assign that single point of contact and support personnel. One note I do want to make, there's no private right of action with respect to continuity of contact. There is no private right of action under RESPA, so these rules are under RESPA with respect to policies and procedures. For the remainder, though, of what I'm about to talk about, there is a private right of action. So I will try to specifically call out as we go through the presentation where there is or isn't, but continuity of contact is a place where, unfortunately, there's no private right of action. So let's talk about the 120-day rule that I alluded to earlier. So this is a place where servicers are prohibited from making a first notice or filing required for foreclosure on the borrower until the borrower is more than 120 days delinquent. But that's subject to two exceptions. These exceptions, namely, are when the servicer's proposed foreclosure is based on a borrower's violation of a due-on-sale clause within the mortgage, or the servicer is joining the foreclosure action of the subordinate lien holder. So let's say Mary, who comes to your office, has a second that's trying to foreclose upon her. That may be a situation that you want to carefully look at the regulation to see if the servicer has a right to join the foreclosure of that second lien holder. The first notice or filing. The first notice or filing is considered on the basis of foreclosure procedure under applicable state law. So, for example, in a judicial foreclosure procedure, in a judicial foreclosure state, this is the first document that's filed in a court or with another judicial body. In a non-judicial foreclosure state, this is the earliest document required to be recorded or published to initiate the foreclosure process. Now, I want to just talk about this a little bit more in depth with respect to the first notice or filing. For those who want more information on this, I would encourage you to go look at the preamble regarding foreclosure protections, namely at the September amendments, because this is when this concept came into the final rules as an amendment. This was a concept that effectively tried to allow borrowers to have pre-foreclosure protections that they might otherwise be entitled to, like notices to cure that would have information about loss mitigation in them, and have the benefit of having that activity, but having the protections from that first notice that might otherwise be filed with a court. And so, again, I would encourage you, if you have more questions, to look at the explanation in the preamble relating to the September amendments. And I will point out the website where that information all lies.
Hey, Jean, this is Becky talking. Some folks are having a little bit of difficulty hearing. You sound a little bit muffled. I don't know if you're on a speaker or something.
How about this? Is that better?
That does sound better. Thank you.
Okay. All right. Sorry about that.
No worries.
So, okay. Now let's talk about when Mary comes into your office and she wants to apply for loss mitigation, which is most likely a lot of the folks that you all will be dealing with. So with respect to protections that borrowers in the loss mitigation process have, there are protections that begin as early as when a borrower makes an oral or written request for a loss mitigation option. That is considered an application. So an application is an oral or written request for a loss mitigation option that is accompanied by any information required by the servicer. There are a bunch of deadlines that, or I should say timelines, that I'm going to walk people through, but I just want to talk generally about the paradigm. So once Mary submits information that she thinks the servicer requires to begin the loss mitigation process, For any application that the servicer receives 45 days before the sale, the servicer must review that, and 5 days after receiving that application, the servicer must send a notice that identifies if the application is either complete or if the information or documents are missing. This is a really critical notice, so I want people to take particular notice of that. And this notice also should contain the dates by which the borrower should return the information into the servicer. Our regulations say that the servicer has to give the borrower reasonable dates, and reasonable dates are defined as one that preserves the maximum borrower rights. And we can go into that more, but in the interest of time, I'm going to continue on with sort of the general paradigm. So once Mary gets this acknowledgement notice, and let's say it identifies that the application is incomplete and that there's additional information or documents missing, at that point, if she sends that information in, the application is considered complete when the servicer requires all information that it requires from the borrower. So I just want to say that again. It's complete when the servicer gets all information it requires from the borrower. So a servicer may require additional information such as an appraisal or whatever else the servicer needs, such as a credit report, but the application under our rules is considered complete when the borrower submits everything that is required of her. In terms of follow-up, a servicer is required, so let's say Mary gets this acknowledgement notice and she sends something in. Maybe the servicer needs more beyond that. She didn't send the right thing in, or she didn't send everything in. Servicer is required to exercise reasonable diligence to obtain necessary information from the borrower to complete that application. So reasonable diligence. This, I think, is frankly going to become a critical concept in terms of what does reasonable diligence mean with respect to obtaining that necessary information from the borrower to complete the application. One protection that is in the middle of all this is that if a borrower submits all of the information that is requested in the acknowledgement notice, so Mary submits everything, servicer requires tax return, additional income about a rental property, whatever. If Mary submits all of that information requested in the acknowledgement notice, at that point, she is considered to have a facially complete application, even if the servicer later determines that additional information is needed. So let's say 30 days later, the servicer says, oh, you know what, now that I'm looking at all the information, Mary, you sent in, I really need X, Y, Z. Well, so long as Mary has provided everything the servicer initially requested in that acknowledgement notice, then she is considered to be facially complete, and from a legal standpoint, her application is treated to be complete. And just to emphasize, the notion of a complete application is really critical to whether your clients get protections from foreclosure. So that's why I'm putting some additional stress on this point. Because if you remember nothing else, the point is to try to get a complete application to the servicer as early as possible in the loss mitigation process, even if there's a foreclosure sale pending. So with respect to when there are foreclosure sales pending, the complete application, and we'll walk through the timeline more in depth, but at the end of the day, for applications required less than 30, for applications received more than 37 days out, a borrower will have certain protections. But if a borrower submits a complete loss mitigation application 37 days or less before a foreclosure sale, then a servicer does not have to follow any of the loss mitigation requirements. So I realize a lot of people that you see probably you're learning about last minute, and hopefully they're still within 37 days, but that would be critical to know when is the foreclosure sale scheduled, because that will trigger certain of these rights or not. So I want to talk about incomplete application.
I just wanted to give you a tiny heads up. In New York, we have, as you know, a very long process. So actually the majority, I think, of our folks tend to come in right around the settlement conference time frame, which thankfully is long before we have the judgment and sale. Not everybody, of course, but many of our clients tend to come in shortly after the pendants is filed.
Great. Okay, so hopefully you will benefit from ample protections under the timeline, and we'll go through that. And I will assume that you're probably talking about clients that are more at least 90 days out from the foreclosure sale, which is really great because then you get the maximum protections possible. So I want to talk briefly before we get into the timeline about incomplete applications. So a servicer is not able to evade the requirements to evaluate a complete loss mitigation application by offering a loss mitigation option based on an incomplete application. So, for example, they can't skirt around trying to help the borrower complete the loss mitigation application by simply saying, "Oh, why don't you, have this offer based on your incomplete information." Because, of course, when the borrower completes the loss mitigation application, they trigger all of these dual tracking protections. There are two exceptions to that. One is when the application is incomplete for a significant amount of time, depending on the circumstances. And then the other exception is when the servicer offers a short-term forbearance option. So let's talk a little more about the first exception. So if a servicer has fulfilled its due diligence obligations to help the borrower complete the loss mitigation option, but that application remains incomplete for a significant period of time, the servicer is then permitted to evaluate the incomplete application and offer a loss mitigation plan to the borrower. So the question is, well, what's a significant period of time? And that may vary, taking into consideration a variety of things such as the timing of the foreclosure process. One example, an application remains incomplete for 15 days. That would be more significant if the borrower were 50 days out from a foreclosure sale as opposed to less than 120 days delinquent on his or her mortgage. Likewise, with respect to the short-term forbearance issue. The short-term forbearance program is one where the servicer is able to offer this loss mitigation option during which the borrower is able to forego making certain payments or portions of payments for a period of time, but not longer than 6 months. So it's really meant to be a short-term forbearance option. I think you all know what short-term forbearance is as compared to a permanent loss mitigation option, so I'm not going to go into that in great depth, but I'm happy to answer more questions as need be. So once a complete application is received, at that point, the servicer must evaluate the complete application within 30 days if they've received that complete application 137 days before the foreclosure sale. Following from that, once the servicer has evaluated the borrower, they have to notify the borrower with a written decision, including any reasons for loan modification denials. So what are some examples of reasons for denials of a loss mitigation application? Well, and I should just take a step back. This is for loan modification denial, so it's not all loss mitigation, not like a short sale or deed in lieu. This notification requirement pertains to loan modification denials. So examples of reasons for denials of a loss mitigation application If an MPV test is the basis for a denial, the servicer must provide the borrower with the inputs used in the MPV test. If an investor requirement is the basis for the denial, then the servicer has to describe the investor requirements. Simply saying that an investor requirement exists is insufficient. Servicers are allowed to follow investor waterfalls to determine eligibility for particular loss mitigation options, but they have to explain the existence of a waterfall as the basis for a loan modification option. So now Mary has her notification. She knows, let's say, it's based on an investor denial. At that point, now we move into the response timelines. So the amount of time that a borrower has to accept or reject a loss mitigation offer varies depending on when the servicer receives the complete application and when the foreclosure sale date is. So, for example, if the complete application was received by the servicer more than 90 days before the foreclosure sale, which it sounds like maybe the case in New York, then the servicer has to give Mary at least 14 days to accept or reject the offer to the extent an offer was granted. If, however, let's say Mary comes for some reason to you late, and the complete loss mitigation application was received by the servicer during a period that's less than those 90 days but more than 37, then the servicer has to provide the borrower with that notification at least 7 days. It has to give the borrower 7 days to accept or reject the offer. Now, appeals. Because you're in New York, it sounds like your clients will get the benefit of the appeals process, which is really great. The appeals process is triggered when a servicer receives a complete or facially complete application 90 or more days before the foreclosure sale, at which point a borrower has appeal rights. If they receive a complete application on day 45, no appeal rights. So let's talk about the appeals process. With respect to the appeals process, the servicer has to have independent personnel review the appeal. The borrower, so Mary, once she decides she wants to appeal, she has to appeal within those 14 days during her response deadline. At that point, the servicer has to review the appeal within 30 days. Let's say the servicer comes back and says to Mary, you know what, we're going to give you a new loan modification offer. At that point, Mary has 14 days to accept or reject that offer. With respect to all of these complete application requirements that I'm talking about, you have private rights of action under these provisions. So I just want to flag that. I also want to flag that investors, whether it's Fannie, Freddie, or other investors, may have additional or different requirements. These rules are meant to be a floor, not a ceiling. So if there are more generous requirements out there, those more generous requirements would still apply. So I know that the timeline and just talking through it is a little bit difficult. So I want to flag the 3 key periods that exist within the paradigm of the loss mitigation protections. So you have the first paradigm, which is 90 or more days. At this point, you have a bunch of different deadlines that fall from 90 or more days, and this includes when there's no foreclosure sale scheduled. So either there's a foreclosure 90 or more days out, or there's no foreclosure sale scheduled. And it sounds like you all in New York are in this first paradigm, which is great because that's where you have the most rights. At that point, once the servicer receives a complete application, and when I talk about receives a complete application, here's a place where I would suggest that with respect to the receipt of the complete application, the question is, when does the servicer receive it? This would be something you could ask the single point of contact or the continuity of contact. This is an important date, so you want to make sure you know what it is. Even better, to the extent that you're able to actually get proof of receipt. That obviously would be excellent. So 90 or more days. This is when, this is summarizing all of the loss mitigation protections we just talked about, the servicer has to send that acknowledgement notice within 5 days. They have to send the written decision and explanation of a loan modification denial within 30 days. The borrower has 14 days to accept or reject the offer, and the borrower has 14 days to appeal a denial. So you have the most rights in that 90 or more days. As you move down to 45 to 89 days, this is sort of the middle of the pack, so to speak. At this point, the servicer still has to send that acknowledgement notice within 5 days of receiving the application, so any application. The servicer has to also send that written decision and explanation of a loan modification denial, if applicable, within 30 days. And the borrower then only has 7 days to accept or reject a loss mitigation offer. There's no appeal rights. Likewise, in 38 to 44 days, there's no appeal rights. There's no acknowledgement notice either within those 5 days. So that is generally how the timeline works. As you get closer to the sale, unfortunately, you get less rights. So, dual tracking restrictions. Before a formal foreclosure process starts, before that first notice or filing, if a servicer receives a complete application, or as we talked about, that facially complete application that should be treated as complete, they may not file a first notice or filing until the following has occurred. So this is only when they can file that first notice or filing. The servicer has denied the borrower's application and the time to appeal that denial has expired, or the borrower appealed and the appeal was denied. So that's one instance. The second instance is that they can only start that foreclosure if the borrower has rejected all of the loss mitigation options. And then finally, if the borrower does not perform as required under the loss mitigation agreement. Regarding a borrower's performance under the loss mitigation agreement, I did want to note 2 things. First off, a borrower is considered to be performing with respect to a short sale offer during the listing or marketing period of a short sale or other similar agreement. However, a borrower may be deemed to fail to perform if there's no approved short sale transaction at the end of the listing or marketing period. So now we have the situation once a foreclosure sale is pending. So once a foreclosure sale is pending, if the servicer receives a complete application more than 37 days before a sale, or the consumer is treated as having a complete application because they've had a facially complete application, which was triggered by their providing everything required under that acknowledgement notice, they get at least 45 days before the sale, then a servicer may not complete the foreclosure until the following has happened. 1, the servicer has denied the borrower's application and the appeals process is either not available to the borrower because they didn't provide the complete application more than 90 days out, or the time for the appeal has expired or the appeal is denied. Likewise, if a servicer may not complete the foreclosure if a borrower has, let me back up, a servicer may not complete a foreclosure until the borrower has rejected all loss mitigation options, or last, a borrower does not perform under the loss mitigation agreement. So I want to talk very briefly about completing a foreclosure. What does that mean? What that means is that a servicer cannot move for a foreclosure judgment. For example, a dispositive motion, like a motion for default judgment on the pleadings or summary judgment, or an order of sale or conduct a sale. So once a servicer receives a complete loss mitigation application, the servicer must promptly instruct any lawyers it has retained not to proceed with the filing for a foreclosure judgment or order of sale, or conduct the sale, and if necessary, file for a continuance with respect to any deadlines for filing a dispositive motion. The servicer can, however, continue litigating, arbitrating, mediating, etc., the foreclosure during the foreclosure process so long as this does not cause or directly result in the issuance of a foreclosure judgment or order of sale, or the conduct of a foreclosure sale, which would violate our regulations. If the servicer has already made a dispositive motion at the time when the borrower completes the loss mitigation application, the servicer has to take reasonable steps to avoid ruling on such a motion or the issuance of such an order until the loss mitigation procedures are completed. If a servicer does this, it has not violated the prohibition on moving for judgment, even if the court goes ahead and grants the servicer's dispositive motion. So now to summarize the timeline of dual tracking restrictions. Again, if a complete application is received 37 days from the foreclosure sale date, then the completion of a pending foreclosure is only allowed under these certain circumstances. Again, we see the same paradigm as the loss mitigation protections, where 90 or more days is going to trigger more rights. So, for example, they can't commence that foreclosure, they can't complete that foreclosure until that complete application is denied and the appeal rights are exhausted, or the borrower rejects a pending offer, including from an appeal, or the borrower fails to perform. So now we're in 45 to 89 days. It's essentially the same, but no appeal rights. And then 38 to 44 days, here is where you're not necessarily going to have the facially complete application within those protections, because that applies when a borrower receives the acknowledgement notice from the start, which is only happens at 45 days. I'm happy to walk through that because I know it's a confusing concept, but in the interest of time, I'm going to continue forward. Again, I just want to flag this timeline, these rules, these restrictions are meant to be a floor, not a ceiling. If an investor has additional protections, including in that 37 days to the foreclosure sale, this is not meant to impact those. So here's a really important provision, the duplicative request provision, that I want to flag. The duplicative request provision is a provision that only requires the servicer to comply with the requirements for a single complete loss mitigation application for a borrower's mortgage account. So this means that if a borrower submits a complete loss mitigation application and, let's say, is denied, but then later seeks additional loss mitigation assistance, the borrower may not be entitled to a second full loss mitigation process under the rules. And here is where I think, given the fact that we're almost at January 10th right now, I did want to flag that if your clients submit a complete loss mitigation application after January 10th, irrespective of what's happened in the past, they should still be entitled to the protections of the rules. So let's say on January 9th, they had received whatever from the servicer. They had a long ongoing process. They should still be entitled to the protections under the rules after January 10th. So that pre-existing conduct is not going to impact them. Servicing transfers. Servicing transfers, I know, are something that has been a focus across the nation, particularly in New York. And here, a few issues I wanted to flag are that, one, the documents and information transferred from the old servicer to the new servicer may count as an application for loss mitigation, which triggers all of the responsibilities of the loss mitigation requirements. So this is something that you will see in the comment to Rule 41I. And this is where I'm citing from. If, for example, the documents constitute a complete loss mitigation application for the new servicer, then the new servicer must treat the documents and information as if they were submitted to the new servicer on the date that they were in fact submitted to the old servicer. So essentially, you should have the continuity of service for the borrower. If servicing on the account is transferred to a new servicer, however, the borrower may be able to apply for loss mitigation again. So that may be one point where the borrower is not going to, or I should say the borrower will have the benefit of being able to apply under the rules once again, given a transfer. Of note, under the policies and procedures provisions that CFPB, AGs, and the prudential regulators enforce, servicers must have policies and procedures reasonably designed to facilitate the transfer of information during servicing transfers to make sure that that information that the borrower has provided to the old servicer completely makes it to the new servicer. So the next section that I want to move into is these are requirements and protections for all borrowers, not just your delinquent borrowers. This is something that you can use at any point. And information requests and notices of error are, in essence, newly upgraded QWRs, or qualified written requests, that consumers may use in order to, 1, obtain information, or 2, request the correction of errors. So in terms of information, let's just talk quickly about what's the sort of information that borrowers can request. So borrowers can request information related to servicing and their mortgage account, with the exception of information that is confidential, proprietary, or privileged, or irrelevant, or overbroad and unduly burdensome. So there are some examples of what confidential, proprietary, or privileged information may include. So this could be information about the servicer's management, the profitability or information provided to investors, information about servicer personnel, including compensation, bonuses, or personnel actions, records relating to examination reports, compliance audits, internal or external investigations, and information protected by attorney-client privilege. Irrelevant information, for example, may include information relating to the servicing of another borrower's loans, training programs for servicing personnel, servicing program guides, investor instructions. Overbroad or unduly burdensome may include requests for an unreasonable volume of documents or information, a request that the servicer could not respond to without exceeding the time limits set for responding to that request, or without incurring unreasonable costs or dedicating unreasonable resources in light of the circumstances. So, for example, such requests might be those that relate to substantially all aspects of servicing, origination, sale, securitization, and foreclosure of the loan, and all recorded mortgage instruments. Requests that are not reasonably understandable, requests that accompany voluminous and tangential discussion or assertions of errors, or requests that require the servicer to provide information in a specific format when the servicer doesn't ordinarily store information in that format. And then there's one other example of requests that are not reasonably likely to assist the borrower with the borrower's accounts. And examples of this include a request for a copy of the front and back of all payment instruments showing payments by the borrower or payments by the servicer to the mortgage owner. A servicer does have to respond to a request that is overbroad and burdensome if the servicer can reasonably identify a valid information request in the submission by the borrower. So what counts as an information request? A qualified written request, QWR, but not a request on a payment coupon or another payment form. So that's the general definition of information request. With respect to notices of error, categories of errors include the failure to properly accept, apply, or credit payment, the failure to pay taxes, insurance, or other charges, the failure to refund money in an escrow account within 20 days after paying the mortgage in full, the imposition of fees that lack a reasonable basis, the failure to provide a timely payoff statement, the failure to provide accurate loss mitigation information, as discussed in the early intervention live and written contact scenarios, the failure to accurately and timely transfer information in a servicing transfer, and violations on the prohibitions on foreclosure referral or foreclosure sale. Note, these categories of errors do not include loan origination, loan underwriting, the sale or securitization of the loan, or decisions to sell, assign, or transfer the servicing of the loan. So with respect to how a borrower can request this, to the extent that a servicer designates a specific address, this address must appear on certain notices and a servicer's website. So for example, the periodic statement that we're going to talk about shortly, the early intervention notice, among other notices. With respect to deadlines, generally a response is required within 30 days. For an information request, it's 10 days if the borrower is requesting information about the identity of the investor, owner, or assignee. If a servicer claims that no response is possible in an information request scenario, it must have conducted a reasonable search for the information and provide the borrower with written notice that the requested information is not available to the servicer, the reason why the servicer has determined that that information is not available, and the contact information for the servicer, including a telephone number in case the borrower needs further assistance. One note, the information is not available if it is not within the servicer's control or possession, or if the information cannot be retrieved in the ordinary course of business through reasonable efforts. So examples of available information include transcripts or tapes of phone calls that are accessible in the ordinary course of business, where the phone calls referred to by the borrower can be identified through reasonable business efforts, or documents stored off-site that the servicer has a right of access to through reasonable efforts in the ordinary course of business. Examples of information that is not available could include information stored on electronic backup media that cannot be accessed by the servicer without undertaking extraordinary efforts to identify and restore the information. Of note, fees for providing information pursuant to an information request are generally prohibited, except if a borrower requests a beneficiary notice. With respect to error request response deadlines, so that pertains to information requests. With respect to error requests, when Mary is contacting her servicer asking them to correct an error, payoffs have to be responded to 7 business days after the notice of error is received. Foreclosure errors, and this is a big important category. So with respect to errors that claim that an improper foreclosure was filed or initiated, there the response has to be either before the foreclosure sale or within 30 business days after the notice of error is received. So just a few points on this. If the servicer cannot investigate and respond within these deadlines, the servicer can comply with these deadlines by canceling or postponing the foreclosure sale and investigating and responding before the rescheduled foreclosure sale, or within 30 business days after the notice of error is received, whichever is earlier. For all other errors, it has to be within 30 business days after the notice of error is received, but this can be extended by 15 days if the servicer sends a notice of extension and the reason for the extension within 30 days. So I want to talk a little more about notices of error because there are additional things required of the servicer here. So Mary files her notice of error, and the servicer must investigate the error. Now, a servicer may request but not require information from Mary regarding the error. And the servicer's response, the substantive response, must identify the errors fixed, including any errors they come upon in the course of their investigation that they've identified, even if Mary hasn't. To the extent that they don't fix the errors, they have to state the reason why not, the documents relied upon, and the way for the borrower to request those documents relied upon. So, for example, for an investigation that results in no errors, a borrower may request the information and documentation relied upon in deciding that there was no error, such as a screenshot of the account showing the amounts credited. This information must be provided at no charge and within 15 days after the borrower requests it, excluding public holidays, Saturdays, etc. So this is 15 business days. Another important protection. Once the servicer receives a notice of error, it cannot furnish adverse information about any payment that's the subject of that notice of error to a credit reporting agency for 60 days. So here I'm going to go through this really quickly on policies and procedures. These are procedures and policies that servicers must have that are reasonably designed to accomplish the following various objectives. They have to be able to access and provide timely and accurate information to borrowers. They have to properly evaluate loss mitigation applications. They have to facilitate the oversight of and compliance by service providers. So service providers to the servicer can include a wide swath of people, including foreclosure attorneys. They have to facilitate the transfer of information during servicing transfers, and they have to inform borrowers of the written error resolution and information request procedures that we just discussed. Again, as I said earlier, there's no private right of action under the policies and procedures requirements, but I still want you all to know about it to the extent that you see that these objectives are not being met. You can let us know. With respect to periodic statements, this is a general requirement now for all borrowers. All borrowers must be provided with periodic statements for each billing cycle, except if a borrower is in bankruptcy, and there are a few other exceptions. This is not required, however, for fixed-rate mortgage loans if there's a coupon book that meets certain requirements. And finally, to the extent that a borrower is delinquent, that periodic statement will have additional really important information that you all will care about. So for example, this will have information about the date on which the borrower became delinquent, a notification of the possible risks such as foreclosure and expenses if the delinquency is not cured, an account history showing for the previous 6 months or period since the last time the account was current, whichever is shorter, the amount remaining past due from each billing cycle, or if any such payment was made on the date when it was credited as fully paid. A notice indicating any loss mitigation program to which the consumer has agreed, if applicable, and also a notice of whether the servicer has made the first notice of filing required by applicable law. The total amount needed to bring the account current, and then there should also be a reference to home ownership counselor information, such as a website address and a HUD toll-free number where the borrower can access lists of housing counselors. So you can see that there's going to be really helpful information on that periodic statement that you will want to look at, including, for example, if there is a foreclosure sale date. Another protection that exists for all borrowers are new protections surrounding force-placed insurance. So with respect to force-placed insurance, a servicer may not charge a borrower for force-placed insurance unless the servicer has a reasonable basis to believe that the borrower has failed to maintain hazard insurance or homeowners required by the loan contract. At that point, if they have a reasonable basis, the servicer has to provide a series of different notices. So I'm going to go through these quickly in light of the time. And ultimately, when the charges for force-placed are actually imposed, the charges for the services have to be for services actually performed and bear a reasonable relationship to the servicer's cost of providing those services. So one thing I want to talk about with the force-placed. Under our definition, force-placed does not include hazard insurance required by the Flood Disaster Protection Act of 1973, i.e. flood insurance required under that act, as well as to other exceptions relating to certain hazard insurances that are purchased by the borrowers. One big change, escrowed borrowers. Servicers may not force-place insurance if the borrower has an escrow account and the servicer can maintain the delinquent borrower's existing account by advancing funds to pay for that existing homeowner's coverage. This is a big change, and it's an important one, and I want to talk about two exceptions related to that, however. So the question is, when is a servicer able to purchase coverage for those who have escrow accounts? Well, a servicer is able to do that if they are unable to disperse funds from the borrower's escrow account to ensure that the borrower's hazard insurance is paid in a timely manner. So when are they considered unable to disperse these funds? They're considered, a servicer is considered unable to disperse these funds if, one, the servicer has a reasonable basis to believe that the borrower's hazard insurance has been canceled or not renewed for reasons other than the non-payment of premium charges. The second is if that borrower's property is vacant. So if the homeowner's has been canceled because the borrower's property is vacant, that would be another example. A servicer, however, is not considered unable to disperse funds because the escrow account contains insufficient funds for paying hazard insurance premiums. So essentially, a servicer has to advance the funds even if the borrower is not paying for them. That's not a reason for the inability to disperse funds. There are other protections for all borrowers. The first being prompt crediting. So crediting being the servicer must promptly apply any periodic payments as of the date it was received, subject to two exceptions. With respect to suspense accounts, if the servicer receives a partial payment, the payment must be held, credited, returned, or held in a suspense account. But when the amount in the suspense account, so let's say a borrower is making partial payments over time, when the amount in the suspense account covers a periodic payment, the servicer must apply the funds to the consumer's account. Other changes are there are going to be a new ARM notice. So if a borrower has an adjustable rate mortgage, they will get a new notice prior to when it adjusts. Likewise, the existing ARM notice will be slightly revised. And then with respect to payoff statements, the servicer must send these to the borrower within a reasonable time, no later than 7 days, if they receive a written request from the borrower. One thing I want to flag, small servicers are exempt from the servicing rules, certain portions of the servicing rules. A small servicer, as you'll see on the slide, includes those who service 5,000 or fewer mortgage loans, each of which is owned by or was originated by the servicer. So that may include some of the entities that you're looking at. It may not to the extent it does. I would encourage you to go to a guide as well as the rules directly that I'm about to discuss. And here's just the general paradigm of all of the requirements that I've been talking about and how they fall, including under which regulation. And then finally, in terms of resources, I was just referring to a guide. There is a guide online among several resources. There's a link to it on this last page. This has very helpful information with respect to all of these topics. Likewise, there's another page we have online that gives the regulation text, the preamble, the official commentary, as well as another guide designed for small businesses. There's a lot of great information on the page if you want to go directly to the text as well as any comments. I would encourage you to do that. Finally, if you want to file a consumer complaint, there's a link to how you can do so right there. And at the end of the day, if you have additional questions beyond what we're talking about here, please feel free to reach out and call me. I welcome that. My numbers are down below. And that's the end at 1:01.
Jean, that's great. Thank you. So just let me reiterate, Jean just offered her personal services to you to offer assistance on these questions. So everybody should have, as I mentioned before, received this PowerPoint. So I encourage you to keep that close and handy. So Jean, we have a number of questions. I don't know if you are able to see them yourself on the dashboard.
I cannot see them.
Okay, so let me just run through them and try to keep them as concise as I can. The first one actually, it's just a basic question that somebody sent me via email. All the letters regarding loan modification offers after the 10th of January now have to comply with the NPV and the investor information. Is that correct?
So to the extent that you're talking about a denial letter, if I understand the question right. Okay, so when we're talking about a denial of a loan modification, so this is a loan modification, then yes, it should have the requisite specific and precise information as required under our rules.
Okay. All right, now I'm just going to try to read these through here. So borrower has 14 days to accept or reject an offer of a loss mitigation option. Borrower has 14 days to appeal a denial of a loan modification application after the servicer provides the denial. Is it 14 days from the date of the letter, or 14 days from the day the borrower receives the letter, or 14 days from something else?
That is a great question. So I believe, and I'm going to check right now, it is when the servicer provides the information. Now, I realize, because we've done some other trainings, that the word provides is not defined within our regs, and I also realize that there is some concern about servicers sending information perhaps a bit later in terms of when, you know, the letter will say one thing, but then the borrower receives the letter a month later or whatever. Right. That would be a situation where you should feel free to contact me or file a consumer complaint because I would be interested in hearing about those situations with respect to how that requirement is actually coming to life.
So hopefully that's something that we can discuss in some of the in-person trainings at a later time to get a better sense of how that shakes out.
Exactly, yep.
Okay. Regarding the borrower's time to appeal, does the term after servicer provides denial mean only a written denial, or does the time run from an oral notification of denial?
So it should be a written denial. So the denial should be in writing.
Okay. What is the financial circumstances of the homeowner changes after the denial? Do they have an opportunity to go through the process again?
So with respect to the changed financial circumstance, the answer, I believe, under our duplicative request provision is to the extent that they've already gone through the process and it's changing. Well, the answer is certainly they should tell the servicer and make sure that their updated financials and updated information is there and considered to the extent that the servicer will do that. That said, in terms of the legal requirements, there is the duplicative request provision. So if a borrower goes through the process, but then later their financial information changes, unfortunately, at this point, I believe that the duplicative request provision would be in place.
Okay. It doesn't mean that if you're working through the court system that they can't, that the court's not going to force them to reevaluate, but simply by these standards, it's not a requirement.
Yes, like I said, these are a floor, not a ceiling. So whatever state law or investor requirements would require, they can build upon this.
Right. Let's see. When do the provisions on servicing transfers take effect?
January 10th.
Right. And is there a suggested form for these information requests and notice of errors?
We will have sample letters coming out online soon, I believe, within the week.
Okay. And I assume there'll be some sort of a broadcast of that?
I'm not sure. Brenda may know better than I, but I think that you should certainly check our website. I don't know if we're going to do a webinar, so to speak, of a sample letter that would be on there, but we'll probably do some press around it.
Okay.
I can forward that to you, too.
Yeah, if there is a press, if there is something that goes out, we will make sure that we send it to our stakeholders who are on our list. So I know several people are on our stakeholder list, but if not, Becky, can they email you directly, and then I can add them to my list, or they can feel free to contact me directly
Sure.
as well to get on that list.
Okay. Is the existence and amount of money in a suspense account required to be reported on the periodic statements?
Is the existence of, I believe the quick answer is yes, but hold on, let me just check just to make sure. So the periodic statement, and this is some of the information I blasted through, I believe it includes, so the answer right now, and I'll follow up with you on this, is it definitely requires the transaction activity and history, which presumably would include that information, but I don't want to tell you the wrong information, so let me check and make sure about that. So the rules say if a statement reflects a partial payment that was placed in a suspense or unapplied funds account, information explaining what must be done for the funds, to be applied. This information must be on the front page of the statement, or alternatively may be included in a separate page enclosed with the periodic statement or letter. So they have to tell you what they do with your money, including in that instance.
Okay. All right then. Let's see. We have a couple.
Yes,
more
it
here.
clearly needs. Yeah, it clearly needs to be reflected on the periodic statement.
Yep. Okay. So do these rules apply to credit unions? I assume that would have to do with the size of the credit union.
to credit unions? I believe yes. The answer is yes. I believe so. The CFPB may not be able to enforce against the credit union depending on the size of the credit union, but it would still be generally applicable as RESPA and TILA are generally applicable across the board.
Okay, that's good to know. Do the federal mortgage, bunch of preemption type questions coming up here. So do the federal mortgage servicing rules preempt New York State mortgage servicing rules?
No.
Okay.
The only place that they might be considered as preempting any state law is the 120-day restriction. So, for example, and this sounds like it's not the case in New York, but if you had a state where you were able to foreclose 60 days after the borrower became delinquent, this would preempt that provision, impact that provision. But like I said, it's a floor, not a ceiling.
Okay, so I think the rest of these questions follow in that vein. So the federal rules are essentially supplementing New York State rules.
Yes,
correct.
Floor, not a ceiling.
Right. And then in what ways do the federal rules provide greater protections? I don't think that you would know those answers, so I think we're going to leave that one for perhaps another day. Okay. And that the New York State rules provide greater protections, point to New York State rules, and the federal rules provide greater protections, point to federal rules. Is that correct? So essentially pick and choose which one is the better one. They're meant to supplement.
Yeah, I mean, I can't provide legal advice, but as a lawyer, I would certainly pick the most favorable regime.
Absolutely, right. Okay, good. Let's see. And I had a follow-up question to one of the first question I asked you, so let's see here. Where did it go? Sorry. The first question I asked you was about loan mod offers and the denials, whether they have to comply with the NPV investor information. And then she followed up and said, what about an offer of a loan mod as opposed to a denial? Do they have to include that information in the offer as well?
I don't believe so, but let me check real quick. I think the quick answer is no, but if I learned something that changes that answer, I'll let you know later, Becky.
Okay. All right. And then let's see, one person asked whether the recording will be available after this webinar, and I am happy to announce that our webinars are going to be available online. And you have to access it through the portal, and if you do not have access to our HOPP portal, please contact me or Michelle or your regional coordinator if you prefer, and we will get you access to it. And that's it, I think, so far.
So again, I just want to invite people, if particularly as you're out there and you're seeing things and you have questions or more important concerns, please contact me. If you want in-depth information on the rules, including regulatory guidance, I can connect you with our rule makers because they know more than I do about the rules. So I just put that offer out there.
That's great. Oh, let's see. We've got a couple of more here. I'm sorry. Where is the survey? Anyways, well, it looks like these are all internal questions here, so that's fine. So the questions for you, Jean, are over. And again, thank you so much. I hope everybody is able to use this information. I'm quite excited to actually start applying it to some things here. So thank you.
Excellent. Okay, well, thank you.
All right. Bye, everybody. Have a good day. Stay warm.
I just announced the CLE code
for
everyone. Anyone that's still on the line. The CLE code is RU9CP. That's RU9CP. That's it.
Thanks, Michelle. Bye, everyone.
Bye-bye.